separate, all right, from an IOTA account or something, if there's a disputed portion of the funds, how far do you have to go to keep that separate? What do you got to do? I mean, you have to create another account, or?
You know, that's a very good question, and there's best practices. Best practices would be, yes, to create another account. Okay, that's not required. That's not required. But if you want to go in front of either the evidentiary panel, or stand in front, or try in the initial stages of a grievance to show how you wanted to be sure there's no issue, that would be a nice fact. Okay, that I wanted to be sure that everybody was taken care of, the client was, everybody knew that there was no chance of commingling, and so at First State Bank I made a IOTA account under the name of John Smith. Okay. And that's where the money is, and your printout shows it. Okay. That would be the best practices. It's not required.
Okay. Are you ever required to interpolate the funds?
You're not required unless there's an order officer in the court to do that, and it's sufficient to keep that in an IOTA or, as you said, another account. There's no requirement to do it. Again, if you're trying to, you know, if there's not an arbitration case, the client has sued you, you want to come with completely clean hands, I can see a situation where you would interpolate. Say, you know, you sued me, you're trying to get, I don't have control of these funds, but now with the district clerk. And so I don't have a problem with that strategy either. In fact, it probably it falls in the category of best practice.
What if it's a third party, not the client, but a third party?
Same applies. I mean, the same responsibility. Both the rule and the trust regulations state that if there's a dispute, you distribute that, and it says this, at your own peril. To me, that sounds like, you know, you shouldn't do it if it's disputed and you can't determine exactly who owes and how much it is.
What if the statute of limitations has expired for the adjudication of that claim?
Boy, now we're getting into, you need to give me a call. That's getting really technical. Statute of limitations for a grievance is 5 years. Now, statute of limitation for the lawsuit, statute of limitation for the grievance, you know, you'd be in pretty good shape.
Statute of limitations to adjudicate the amount owed.
Well, I can see a situation, even if that has run out and you still had exposure under the 5-year ethics rule, that might be a problem. Okay? But all of that deals with, first of all, and what it says in here, is that when that settlement happens, the first requirement is notice. Okay? Now, you can't hold back and say, well, now it's run out 5 years, and then you never gave notice, because that will get you in trouble. Right. So you've done everything, you try to get a hold of them, you can't find them, yada, 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 all that stuff, then that's a different thing. And that, even that situation, I might even interpolate that just to make sure there's no one coming back, or a relative comes back, or somebody's died. I mean, you know, if we're talking about $200, no big deal. 20 million, kind of a big deal. Okay? Yes, sir.
You mentioned that the Office of the Disciplinary Counsel, Chief Disciplinary Counsel, was threatening to take this one up to the Supremes. How often do they threaten tactics like that, and are they bound by the same rules as the rest of us?
Wow, you have not done grievance work. I was listening to NPR, and NPR was talking about how some of our big banks are kind of doing some of the practices they did under the theory that if you're, you know, a multinational huge bank and you do some of this, nobody's going to do anything to you. Okay? Applying that same theory to the Office of Chief Disciplinary Counsel, there are certain people that are kind of the gurus in this area. One is a woman by the name of Lillian Hardwick, Bob Short out of the University of Houston. They have 3 volumes, big stuff. Jim McCormick in Austin, Chuck Heron, these guys and gals that I've talked to, they can't think of a single instance where a disciplinary counsel has ever been disciplined. They can't think of a single instance where a Rule 13 violation, in fact, Mr. Smitherman, in his case, filed a Rule 13, after he won the case, okay, filed a Rule 13 for sanctions and for expenses, and it was dismissed. So that is one of my crusades, is that the Office of Chief Disciplinary Counsel disciplinary counsel are completely immune at the present time. And we just, in fact, the new pamphlet that came out from the Commission for Lawyer Discipline talks about some of the cases they have handled with prosecuting DAs. The Michael Morton case, for instance, DAs, the Office of Chief Disciplinary Counsel was involved in that. A guy by the name of Anthony Graves, case that I was involved in getting the grievance filed against the district attorney in that case, and that's going forward. They talk about, you know, how we've involved with making sure DAs, if they do something wrong, can be grieved, judges, but they never talk about the palace guards, and that's wrong as far as I'm concerned. So that's another lecture. That's next year's lecture. Okay, we're going to go. It's real quickly. I'm going to talk just a minute about the Bennett case, which is very, very interesting. And it deals with the contract, which I think is there, interesting, that you have in your brochure. And the interesting thing about that, there are 3 places in that contract where it references that you should go talk to another attorney. My thought was that if you are dealing with an arbitration, and the case itself, I don't have time to go into it a lot, was kind of a quirky case, you needed to have an attorney look at it. And an attorney looked at it. In fact, not only an attorney looked at it, but a sitting appellate judge who is a family friend of the complainant, Mr. Land, a judge by the name of Hollis Horton, down in, I believe, Corpus, wrote a letter to Mr. Land saying, I've looked at this, these are my opinion, da-da-da, but I can't really, you know, bail you, I'm sitting judge, da-da-da. So he received legal advice at the time of the contract, and the contract was written, okay? We go forward, of course he gets unhappy, thinks I'm charging too much. He then, we have an arbitration clause, we go to arbitration, the arbitration goes against me. I decide under the rules of both the Houston Bar Association and of the Texas Arbitration Act, I have a right to appeal. I take that appeal, a grievance is filed. The grievance ends up being tried to a judge by the name of Carmen Kelsey, who was a sitting juvenile judge who not only had never tried a disbarment case, had never tried a civil case. Well, I had the pleasure of being Assistant U.S. Attorney in San Antonio, over there for altogether 3 years, brought over the president, former president of the San Antonio Bar Association, real close friend of mine by the name of Dan Naranjo. She would not let him or any of my other experts testify because, in her words, I don't need to be told what the law is. Okay, so we go forward. She finds that I committed professional misconduct doing this. One, I delayed it by taking an appeal, even though I have an absolute right to. And then, at the time that I was fired, there was an unearned fee. Well, we had documented, and this didn't become part of the case, because we had documented that he had been billed monthly, and all the money had been distributed according to our fee agreement. Okay, but that was one of the issues in the case. The judge not only decided to find that I committed professional misconduct, but entered a disbarment order, and so that was a little bit unusual. That's now on appeal, and we feel very comfortable for a variety of reasons that hopefully will be changed by the Court of Appeals. But that's what can happen dealing with one of these issues of a fee dispute and how you don't want that to happen to you. So I think we're at 1 o'clock. I'm going to be cognizant of your time. I'm happy to, I think I have a Griffin salad here that I haven't had a chance to eat, so I'm going to hang around and eat my salad. You have my name and number if there's an issue there, and I appreciate your time.
Thank you so much.
I did not charge the $700 that some other CLEs cost, so I hope you appreciate that, and I enjoyed being here.
Absolutely. Thank you.